Gordon Spring, thanks very much for joining us today. You've been involved in perhaps Australia's largest litigation matter involving a real estate agency. Can you tell us about the background to how you ended up in the High Court?
Thanks, Peter. Yeah, certainly can. Back then I was working for a company by the name of LJ Hooker Monavale, which is situated on the northern beaches of Sydney. Now where the northern beaches of Sydney is, for those that are outside the Sydney area, we're about 35-40 minutes north of the city. It's a beachside suburb that is surrounded by Pittwater on one side, which they renowned as one of the best yachting paradises in the world, and also we're fronted by beaches on the other side. So we're just basically a peninsula. So the lifestyle on the northern beaches is a little bit more laid back, a little bit more beaches lifestyle, and the property that we're talking about today is a property at Monavale, which was a waterfront property.
And what about the background to this litigation? How did it all come about?
Basically, what had happened, we'd had 2-3 inspections on the property over the period before it actually physically went to auction. There was a brochure that we represented which had some various photos of the property, some council water rates and land size depicting just some descriptive information on the property. We also represented a survey, and the survey defined where the high water mark was. The survey that we represented, which was highlighted to us after the sale had gone through and the purchase was consummated and they were going through the settlement, Mr. and Mrs. Butcher made their inquiries with council because they wanted to renovate the property. There was if I may just use my hands, there was a swimming pool that actually went east-west actually on the property, and he wanted to turn the swimming pool to actually go north-south to the water's edge. All right. What was discovered was that the high water mark, which was represented in a survey that was actually given to us, was not, it was actually shown on a survey that it was north of where the pool boundary was, but in actual fact it was actually in the centre of the pool. The high water mark went through the centre of the pool. So when Mr. Butcher made his inquiries, they said there is no way they will allow him to actually touch the pool. If he wants to touch the pool, he will lose the pool. At that stage, he actually wanted to rescind the contract, had released a deposit of a part deposit of $200,000 to the vendor, which the vendor had disposed of, and had to go through the process of suing and going down that track.
Now, Gordon, it sounds like the survey diagram was an integral part to this litigation. Where did your office get the survey diagram that they put on the brochure?
The survey at the time was taken from the contract for sale that was provided to us by the vendor and the vendor's solicitors.
Can you tell us some of the reasons why the court found in your favour?
In my opinion, there's two main reasons why the court found in our favour. It's one to do with the way we actually go through our reporting process, and also all our brochures, and if you have a sample of the original brochure that we use, we do have a disclaimer on the bottom of all our actual brochures which actually state that we represent, but we don't actually we can't guarantee any of the information that's provided to us by a vendor or solicitor. We always advise any particular purchaser to please make their own inquiries. And the fact of the matter, because of that disclosure statement we have at the bottom of our brochure, we weren't giving any warranties or representations of the information. We just provided people with the information, but it does clearly state there that you please make your own inquiries, because we are real estate agents and we are there to try and gather information to the best of our knowledge from what an owner will tell us, but we do not know for one moment if that is 100% true or not.
What sort of money would you have potentially been up for if you lost in the High Court in terms of damages or legal fees?
I would say if we ended up having to put our hand in our pocket, it wouldn't be me personally because I was a salesperson employed by that company at the time, but it'd be to the tune of about $500,000.
plus then if you do lose, you ordinarily pay the other side's costs. So if you're paying costs of $500,000 plus
damages,
the deposit, interest and the other side's legal fees, this is potentially blowing out to over $1 million.
It potentially could have closed the business. It didn't factor in my head as a salesperson back then, or what the implications could be if we actually did lose. But you know, when you put it to me in that terminology, I mean, that could have destroyed the business, and the business may not be there today.
Most agents would expect this sort of thing couldn't happen to them. Having been through this experience now, what advice would you give to fellow agents?
Make sure that when you work in that type of agency, or you're asked to buy an agency, that you have disclaimers on the bottom of your paperwork, on any documentation that is given out there to the public. Because at the end of the day, you really don't know what you're representing. I mean, that's what was highlighted to me. The assumption was that you get the documentation that's provided to you by the client solicitor, and it's still an assumption today that when you get that, that's correct. And it's been highlighted to us that sometimes it's not the case. I went through a process where I was very belittled. I was asked to stand up in a court of law, in a witness box, and cross-examined, and I was made to feel like an actual criminal. You know, at the time, it most probably took up 2 years of my life, in between trying to make an income and concentrate on listing other properties and selling properties. You start to lose faith with the industry as well, because you think that everyone's out there to have a go at you, and all you're trying to do is just do your job.
After being to court in such a big case, have you made any changes inside your own office?
Basically anything that is handed out there in the public arena has a disclaimer on it. Everything's written, and everyone in the office either has a written diary or they have a PDA. I insist on it. There is no other way that they work in my business. What I do educate my agents to say when they're out there in the field, that if they don't know, do not say. Just say they don't know, all right? Because people actually appreciate people that don't lie or try and make it up. Tell people you don't know, but you'll find out the information.
So, in a nutshell, if you had to give advice to your colleagues in the industry, it would be be careful what you tell vendors.
Very much so.
Make sure the information you pass on can be checked by your clients.
Yes.
And make sure you have well-drafted disclaimers. I think the disclaimer you had was not only on the front page but also on the back page, which turned out to be quite important too.
I can't even tell you back then if I ever read that disclaimer. I didn't even know that there was one on there, to be quite frank. But fortunately there was, because all I was worried about at the time, as most salespeople are, or property managers when you're trying to lease something, is trying to close the deal. Trying to get someone interested and trying to hopefully, well, if I can get that, I'm going to earn this much, because that's what you do when you're a young up-and-coming agent. You're spending the money before you even made it. So the word of advice is make sure that your in-house stuff has been taken care of, so that you don't have to go through what I've been through.
Gordon, this is a fantastic win, not only for yourself, but also for the real estate industry at large. Congratulations, and thanks very much for your time.
You're welcome. Thank you, Peter. Thanks.